Good afternoon and welcome to another episode of the Dairy Signal. We're so excited that you've joined us here on this Tuesday, July 21st, to learn all about farm estate planning, which I'm laughing a little bit looking at the slide, a whole different animal, which is the case. Today we're here, we have the expert Troy Schneider, shareholder and attorney with Men Law Firm. So during the course of the next hour, feel free to ask Troy all of your questions. You can do so utilizing our system here on the Dairy Signal, and we'd be happy to get to any and all of your questions today. But with that, I guess, Troy, go ahead and take it away.
Sure. Thanks a lot, Emily. Well, this is an important topic, and sometimes I'm afraid when I talk about this topic that it's been talked about so much that people get a little bored hearing about it. But you know, but hopefully provides some sort of, you can grab something from this that others have not talked about. PDPW, I still call it PDPW, is they were one of the first organizations that really started talking about this topic. Now everybody seems to have kind of latched on, and even the farm lobbying organizations, they have everybody has a podcast now, and farm succession, estate planning is kind of, everybody does it. So, but PDPW, I think it's kind of neat that they were one of the first ones to see how important of a topic this really is. So why do you do an estate plan? So an estate plan is a well-developed estate plan assures that your goals for your family and the farm continue to move forward after your death. In order for attorneys or your advisors to really help you put together a really solid estate plan, they have to understand your goals and objectives and the financial situation and unique circumstances of your farm. And they also have to understand your farm transfer plan as well too. And I guess that makes estate planning just is not a will. When I meet with people regarding their estate plan, we always kind of go through what the goals and objectives are. And really these goals and objectives, everybody kind of shares these kind of same goals and objectives to provide the surviving spouse with financial security, to protect the farm in case of a divorce or a surviving spouse's long-term illness, to keep investing cash flow in the farm, to continue the farm legacy, to treat children who left the farm fairly and gain their acceptance of the estate plan, and to avoid income taxes, because we know farmers never like to pay taxes, to avoid any estate taxes, basically wealth transfer taxes, to avoid probate, because we don't want to pay lawyers to do that stuff, and to minimize the cost of transferring the estate to the surviving spouse or when the surviving spouse passes to the children. Now, again, everybody has these same objectives, but it's really the estate planners, attorneys' job and their advisors to try to help the couple, the individual, try to prioritize these different objectives. Again, in order for a good estate planning attorney to understand everything that's going on, you got to understand where the farm finances are at. So you got to know what the farm assets consist of, what their non-farm assets consist of, and what kind of assets are available possibly to non-farm children, etc. In a nutshell, a good farm estate plan really just starts with good information. And part of that is evaluating the current situation of the farm. For example, how well is the farm cash flowing? If you've got successors on the farm or potential successors, are they ready to assume ownership and management of the farm? How well do the kids all get along? How do they resolve conflict? If you're a married couple and you've got some children that are involved in the farm, but yet because of age, some aren't ready, how do you want to provide a structure so that they have the opportunity to join the farm rather than them just being out of luck because you died too early, so to speak? Again, you have to evaluate what assets are necessary to farm for the farm to continue, and to evaluate really what should the non-farm kids inherit. And also to have a discussion about the risks of long-term care. In other words, what if one of the spouses, what if somebody went to the nursing home? How would that impact the cash flow needs of the farm? And what are the you want to take advantage of the tools that are out there to protect assets in the event of long-term care? Now, decades ago, you kind of relied on some old methods to take care of things in the event of your disability or death. And really, estate planning is talking about those two different circumstances. Your disability, meaning your inability to manage the inability to manage your own financial affairs or make decisions for yourself, and to transfer assets upon death. Both of those are an important part of the estate plan. I mean, years ago, you used to go to court to get guardianships done and to probate a will. Well, now we've got things like powers of attorney, marital property agreements, and trusts and beneficiary designations, all to avoid probate or to make things easier in case you can't make decisions for yourself any longer. Also, with regard to nursing home risk, the medical assistant, your eligibility for medical assistance has become much more restrictive. In other words, it's not as easy to apply for the government aid anymore than it used to be. So now you have to use some sort of fancier tools to minimize that risk. Just getting, I guess, in a little deeper into what some of the function of some of what these different estate planning documents are. So everybody should have a financial power of attorney document, which is called a durable power of attorney. The reason why they call it durable is because it survives your disability. So a lot of powers of attorney cease upon disability, but a durable financial power of attorney continues post your disability. You designate people to manage your financial affairs if you are unable to. And you can amend and revoke that document anytime. And you have the choice to either what we call your agents, or like I really like to refer them to, your decision maker. You can give them power immediately, or you can say that they only have the power if I'm suffering from a disability. Also, you should make sure you carefully select your agent or co-agents. And usually financial powers of attorney have requirements for accounting. In other words, they have to keep track of where the money goes. And each person's financial power of attorney should include all the powers found in the Wisconsin statutes to make sure they can manage your financial affairs in the efficient manner in case you were disabled or unable to manage them. Yes.
Troy, on that note, you've mentioned that they have to track the financials. Who is the one, like, is there a system in place to ensure that they're being good stewards of your dollars, or how is that, I guess, looked after?
So basically, if you put it in your document, that usually language is used such that every year or 6 months they have to provide any potential beneficiaries of yours records to show how they're managing your finances for you. So, and I can't stress it's very important to have the right people in place taking care of that, because think about it. If you're disabled and you give this financial agent of yours a lot of power, they can almost destroy the estate plan you put in place because they would have disposed of all these assets during your inability. So it's really important to make sure that they're being held accountable for all of their actions.
Thank you.
Also, in your financial power of attorney, consider that you may want to break up the powers a little bit. You might want to have some people take care of your personal affairs, but then you might appoint what's called farm agents that take care of the farm affairs. Also, you want to make sure your financial power of attorney has that the agent does have the power to guarantee loans for the farm, and so the farm doesn't have to stand still while you're disabled. Also, there should be put provisions in there to make sure that they have the power to divest assets. Translation: if your disability turns into something what looks more to be a long-term care event, well, you want to start divesting assets or getting rid of assets in case so you can qualify for medical assistance. You're going to want to make sure that your power of attorney has gifting powers so that that can occur. And also, your power of attorney document should make sure that the payment is there to take care of long-term care expenses and such. So, if you didn't have this financial power of attorney, you would have to go to court to get what's called a guardian of the estate appointed. You want to avoid that by just having this very, very simple this document so that you don't have to go to court to do a guardianship proceeding. That is, same thing applies for a power of attorney for healthcare. You want to make sure that you appointed people to take care, make medical decisions for you, or if you aren't able to as well. You want to make sure that that power of attorney, your healthcare power of attorney, has broad powers to disclose and access medical information. As we're all aware, we're aware of the HIPAA laws and how difficult it can be to access medical information if you're not the person themselves. So we want to make sure that your power of attorney agent has those powers. And you want to make sure that they can do things like execute authorizations and make healthcare decisions for you. My preference for a healthcare power of attorney usually lies in giving your healthcare agent broad powers to make healthcare decisions for you. In the typical state form, because a lot of times hospitals will hand out the Department of Health and Family Services form. You're kind of familiar with the check the box items on that healthcare form. Not that that's a bad approach, but my personal preference is to give your agent broad authority to make the decision for themselves rather than to check the box. Because quite frankly, if you're somebody who's in your 60s or 70s, you might approach your healthcare decisions differently than if you're in your 80s or 90s. Well, the check the box method doesn't really account for that kind of, flexibility. Again, my preference is that you're appointing people who you trust. Let them then make the decision for you. Also, any standard farm estate plan should include a marital property agreement. Marital property agreements can serve multiple purposes for an estate plan. They can make sure that you gifted assets are your individual property. And in Wisconsin, you can classify all of your property as survivorship marital property. What that does, it allows for an easy transfer of assets from a deceased spouse to a surviving spouse without having to go through probate. Finally, usually your estate plan consists of a revocable living trust, which a living trust is not a will, it's a trust. The disadvantages of will is you have to go through probate court to transfer assets upon death. Versus if you use a trust, you don't have to. Wills transfer assets upon death. A trust does not. Wills transfer assets upon death. A trust transfers assets upon death. They do the exact same thing. It's just that wills have to go through probate court where trusts do not. In your revocable trust, you want to make sure that you appoint the right decision makers called your fiduciaries. Also, the nice part about a trust is it often provides the opportunity to state your intentions. In the trusts we draft, we often put a statement of intentions type of paragraph in the beginning of the trust. There's this concept called an ethical will. It actually comes from the Jewish religion, where people would write down how they felt, how they wanted remembered, and what was important to them while they were alive. It has nothing to do with transferring assets or money stuff. It's basically a transfer of your value system to your heirs. Again, a trust that really drills down into somebody of you being able to speak to your loved ones from your grave. That's really what a good trust is all about. It's not only making things easy from a money standpoint. Again, selecting fiduciaries don't underestimate the important decision it is to appoint the right people to make decision to carry out your intentions. So I always say if you don't know how to do something while you're alive in your estate plan, at least appoint the right people, because good people make good decisions. So appoint the good people in your estate plan. Also, when you're appointing people to be your decision makers, consider having a couple of them appointed at the same time. That can provide a good check and balance to make sure that everybody's behaving or thinking properly. So, and if the children, for example, don't get along, consider appointing somebody who's what they call an independent trustee. Basically, somebody who's not going to receive any money from your estate, so they don't have necessarily a vested interest in how things shake out. So, and again, sometimes that can be a trusted friend, somebody in the industry, that kind of thing. In your trust, you could also consider appointing what they call trust advisors and trust protectors. Going to the next slide. What those different functions are, trust advisors are, if you've got a trust set up that has to be administered for quite some time after your death, then consider maybe somebody should make sure that the farm decisions are made by the farm people. So farm people could be appointed as trust advisors. Also, the possibility of appointing trust protectors. What a trust protector does in your revocable trust, you're appointing people to change things if things have to be changed. So again, when you're alive, it's a revocable trust, meaning you or your spouse can change it as many times as you want to. The moment both of you are gone, it becomes an irrevocable trust, meaning you can't change it. But if you appoint people who are trust protectors, they can still make some changes, given the powers that are needed. So in case the circumstances dictate that certain things have to be changed.
Troy, on that note, is there a certain point, say you are getting up there in age and your husband has passed away and you want to update the trust, are there certain factors in place, like in terms of thinking about like if you have dementia or another illness that might not make you be at the same state of mind as you were when you wrote the original trust? Are there factors like that or protections in place? Or is it because you're still alive, you're able to make updates until the day that you pass away? How does that work, Troy?
Yeah, a lot of times when you get to, because of age, and with age comes the greater risk of having diminished capacity or making good decisions. You appoint people to be maybe co-agents with you. So basically, you're putting self-imposed handcuffs on yourself, so to speak, so that you don't get into the trap that you talk about, Emily. So,
Okay. Thank you.
also this trust decanting stuff, that sounds like a very fancy kind of off the wall thing. When the states, including Wisconsin, adopted this new trust code, they talk about decanting. So where that may come into play, for example, is let's say you drafted a trust back when the estate tax exemption was much lower than the current 15 million exemption. Well, you might have had trusts that wanted to take care of the estate tax exemption issue, but yet and basically remove assets from your estate when you died. But now for income tax purposes, actually it might be good that they're in your estate because the exemption is so high. This trust decanting power can then basically change trusts around to maximize tax benefits. So the next slide that I wanted to talk about is a little bit of beneficiary designations. So I can't stress to you how important reviewing your beneficiary designations are. So if you anything with a beneficiary designation on it does not have to go through probate court because it passes by the beneficiary that you have on it. So for a lot of people, and for a lot of what I call normal people, people who don't farm, they're the normal people. They can transfer their assets without probate just by having beneficiary designations on their assets. But sometimes what happens is you put the beneficiary designation one way and your revocable trust provides for your plan of distribution in another way, and they're not aligned with each other. So you got to be very careful to make sure that your beneficiary designations and your trust are functioning together. And sometimes it makes the most sense to list your trust as a beneficiary on your beneficiary designee on certain assets. All to avoid probate stuff, but also to make sure your ultimate plan of distribution is met. And I know that's a lot of stuff, but again, it's very, very situational. So you want to make sure that things are done the correct way for your situation.
And Troy, on that situation, is it as big of a deal if there's still one surviving spouse? Like, does it automatic and wherever does it just automatically if they're the beneficiary and they're married that they get the assets, or how does, like, for example, life insurance, say the husband passes away, does the life insurance just automatically go to the spouse because they're still living, or how does that work, or do they need to put it into the trust? I guess, is there a specific states obviously have different marital laws, but like for here in Wisconsin, how does it work? Does it still need to go to probate in the event it doesn't have a trust set up?
Good question, Emily. Usually, when you have a married couple where children are all born to the marriage and it's a first marriage situation, not a second marriage situation, it's easiest just to list the spouse as the primary beneficiary and then usually the trust as the contingent beneficiary. Because quite frankly, it cuts down on the paperwork mumbo jumbo if you just list the spouse as the prime beneficiary and you can just go to the insurance company and and the proceeds are paid out. Versus if you name the trust, it can create a couple more steps. Um, but sometimes in a second marriage situations, those steps are necessary because then because you wanted to follow a certain plan of distribution you and your spouse have outlined because of the second marriage type situation. So again, it's very situational, but what you're trying to look for is the easiest path to follow what your intentions are.
Makes sense. Thank you.
So, so now we get to talk about some tax stuff a little bit. So why in Wisconsin, it's really important to have your property owned as marital property. Um, so we've talked a lot about this concept called stepped up basis. And in plain English, what it means is if you buy an asset for $100,000 and you sold that asset for $900,000, during life you'd have $800,000 of gain to recognize. Well, if you lived in Michigan, for example, a non-marital property state, and husband dies, and you sell that same property for $900,000, well, husband's one half you paid no tax on because they got a stepped up new cost basis to a data to fair market value at the time of death. But the wife still has to pay the gain on her half. If you live in a community property state, like wait till what's this explained on the right, in a community property state like Wisconsin, and Wisconsin is one of 9 marital property states, you get a stepped up basis on both halves, both the surviving spouse and the deceased spouse. And you're saying that doesn't make any sense? Well, it's tax laws. They don't have to make any sense, okay? Because politicians wrote them. But it's one advantage of being in a marital property state with the double step. And you want to take full advantage of that tax provision in your marital property agreement.
So then, Troy, on that, so say you're in Michigan, if you just the husband owns the property, that's where the situation came into play. But if both the husband and wife were listed as owners of the property, then it wouldn't be an issue? Or how does that work?
Yeah, if you lived in Michigan and husband owned it solely, and you then and he died, you get the full step because he owns the 100% of it. But of course, we don't know which spouse will die first, usually. So then, um, usually you're kind of stuck where you only get the half step. And you could say, well, if my spouse was sick, I'll just make the asset transfers right immediately before death. Well, the IRS is smart to that too, so they pull back in. You can't make at death transfers to take advantage of tax provisions, unfortunately. So
Well, I'm glad we live in Wisconsin, I guess.
one of the advantages of a marital property state, yes, yeah, yeah. So so the other tax thing I want to talk about is the federal estate tax exemption. As you know, under there's two different areas. What we talked about just before was income taxes. Now we're talking about estate tax. The estate tax is basically a wealth transfer tax. Under current law, we have a $15 million exemption. In other words, you only pay the estate tax if you're worth more than $15 million when you die. So a married couple gets a $30 million freebie before, but anything above the 15 million is taxed at 40%, which is a hefty tax rate. Also, you can make gifts of 19,000 per donor per donee and not use up any of your $15 million credit. So, like for example, Emily, if you had 3 kids, you can gift them each $19,000 and not use up any of your $15 million credit. And if you're married, both you and your spouse can gift each of the kids 38 million and not use up any of your credits. So it's a very powerful way to move assets if you do have potential estate tax exposure without having to do a lot of paperwork and still just do at least annual exclusion gifting.
And Troy, is that annual exclusion gifting to anyone? So like if it was family members, if it was a nonprofit, 501(c)(3), or is there different gift levels for like if you're donating to specific nonprofits?
No, I mean it's
Um,
a per donor per donee.
okay.
So yeah, yep. The advantage of with the nonprofits, as an aside, like if you do also have an estate tax deduction for donating to nonprofits. So I guess that's our plug for the foundation for today, I guess.
Yeah,
So
right. Dairy's Foundation, remember. And it probably could also be written into your estate planning as well if you plan gift. But yeah,
correct.
okay,
Yep.
perfect. Thanks, Troy.
So kind of a couple slides behind here. One other thing with regard to, again, when they changed the estate tax rules several years ago, they also allowed for portability. What portability is, if you're a married couple and your spouse dies, you can actually take their $15 million exemption and keep it for yourself. So husband and wife, a husband dies, he can keep under, and if he died in 2026, wife can have the 15 million exemption and her exemption as well. So all you have to do is file a tax return with the IRS saying you wish to port your spouse's credit over to yourself. Again, I kind of talked about the lifetime gifting and how easy it can be just to move assets during life. And why would you want to do that? If you do have potential estate tax exposure, it's a good way to move, especially assets that are appreciating in value very quickly, out of your estate so that the appreciation occurs in your family members' estate. Another powerful way to move assets if you do have an estate tax exposure is to gift not assets or cash, but business interests, business entity interests instead. Why is that important? Because if you gift LLC membership interests, shares of stock, and you are gifting the minority interest or the non-voting interests, you could take a discount off that value. And kind of what's illustrated here is like if you had a company that was worth 2 million and you're gifting 49%, you would think, well, I'm making a $980,000 gift. Well, but if you gift non-voting interests or minority interest, your gift instead of being 980,000, you hire the right valuation people to put, I call the hocus pocus valuation paperwork together. You can tell the IRS that my gift is not worth 980, it's only worth 663,000 because of the various discounts that are applicable to transferring non-voting or interests that aren't publicly traded, that kind of thing. So again, if you have an estate tax issue, there's a lot of different tools out there to make sure that you don't have to pay the estate tax. And again, some of that's beyond this article. That could be a whole different seminar all in itself for days, actually. But there are some very unique and very somewhat complicated methods to do that. Again, I list just a couple examples here. And I'll just give you, this is what some of those kind of complex examples can look like on a flow chart. So again, beyond the scope of what today's seminar is all about, but again, you want to make, if you have a large farm and you haven't done a lot of transfer planning and you do have an estate tax exposure issue, there are methods that can be used to minimize that exposure. So going back to a little bit to just farm estate planning in general, farm transfer planning has kind of always been the same. If son or daughter was interested in a farm, what you kind of did is you kind of transferred the cattle and machinery and the cattle and equipment to them first. Then usually you sold the building site to them, and the last thing you kind of transferred to them was the cropland. Well, in your farm estate plan, it kind of, and believe it or not, as much as we talk about succession planning, it kind of follows that same kind of procedure in a lot of ways. It can be a little more complicated with the different business entities and things like that, but it's always been that kind of focus to transfer operating assets to the successor generation first. And again, you should coordinate your trust provisions to have that kind of transfer planning align with your at-life planning as well, too. I mean, really, in this farm estate plan is your farm transfer plan that continues that transfer plan after your death. Death happened to cut short the time period that you were operating under for your farm transfer plan. Some methods you could use in your trust, to transfer farm assets are, if your heirs aren't quite ready to, you don't think they necessarily, quote unquote, deserve all of it yet because they haven't built up enough, quote unquote, sweat equity. There's provisions in your trust that can be used to transfer assets over a period of time in the trust itself. That's really important if your ages of children expand, let's say between the oldest and the youngest, there's 15 years difference. Well, you might want to build provisions in your trust that hold back farm assets so that the one that's on the tail end has the same opportunities that the ones of their older siblings. Again, those kind of things can all be built into your trust. Also, there should be an effective method for how you value like business entity interests and an effective way for them to pay for those business interests from their non-farm heirs over a period of time. One of the common farm estate planning issues is the farm real estate. Well, first of all, it's really important for couples who are doing their estate planning to identify what that farm, what 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 real estate we're talking about. In some areas of the state, or in farming world, there's some farm real estate that is more recreational land, hunting land, that kind of stuff, bow land that has not a very impactful. It's not very impactful to the farm. There's also some areas of the state where, well, the housing developments are knocking on the door, you know? So what does that look like as well, too, for identifying farm real estate? And again, just like you can about transferring farm um, assets over a period of time, especially when there's differences in ages of heirs and children and such, you can do the same thing with the farm real estate as well, too. Also, parents are sometimes concerned of like, well, we in our trust we transferred all this farm real estate to our children, our not on farm children, because they need the dirt to farm. What happens if they just turn around and sold it? A lot of times in living trust, we provide what we call, the term of art is sometimes use clawback provisions, where if they do turn around and sell it, perhaps they got to share proceeds of that sale to their non-farm siblings as well, too. Because that's not the reason why you gave them the quote unquote good deal in your living trust. Also, both in our farm and non-farm real estate, we talk about we there's a lot of times parents have the idea of children should own real estate together, and George Tuig always had a good example. He always asked clients who would come to him and say, well, I want my 5 children to co-own this land together, and they'll all get along, don't worry about it. And he always asked them, well, which one of your siblings would you have liked to have co-owned land with? And they always say, well, none of them. So his point was, why are you setting your children up for something that you didn't like yourself? You know, and George was being kind of just wanted his client to think about what they were doing. But it is, of course, obviously possible for people to co-own real estate together. But in your estate plan, it's really important to kind of establish what those rules of the co-owned farm real estate are. Perhaps you need to talk about how decisions are made with regard to the real estate. You need to provide limitations on the transfers of the ownership of the real estate. Also, you can talk about what basically of that co-owned real estate, putting buy-sell provisions. If you co-own the real estate together, well, who can you transfer it to? And if you do want to get out, perhaps you put a discount on your exit price if you really did want to get out of the real estate entity. Again, all very important things to talk about with regard to non-farm real estate.
So Troy, on that note, obviously the subject of putting all the kids on the same land is trying to be out of fairness. I guess what really is fair in terms of if you don't put everyone on the land all together, especially knowing that you might have some children that are returning to the farm, some that don't want anything to do with the farm. I guess what is most common, or what do you see is occurs in those situations where you have, say, one child coming back to the farm and one child not coming back to the farm in terms of the estate planning?
I'm going to give you the lawyer answer, Emily. It depends. Everybody. But I'm saying that not to be a smart aleck, but I'm saying that because every situation is different. Everybody's value systems are different. Everybody's financial situation is different. Everybody's readiness of farm heirs is different. Everybody's got different numbers of kids. So there truly is no right or wrong answer with regard to what is fair. Basically, you have to take your priorities and your situation and work with your advisors to see what to come into that magic formula of what is fair. So, so how was that for a non-answer to your question,
That's
Emily?
kind of what I figured the answer would be. Everyone is unique. Every situation is unique, and I always hear like it's better to sort it out now while everyone is still living than to have to worry about it after mom and dad have passed away, and now their a sibling might not talk to you for the rest of your life because of some they didn't believe in something or the deal didn't go as they thought it would. Whereas it's like we do estate planning to plan for these situations and every situation is unique. So, totally agree, Troy.
Yep. And it's important what I find based on my experience is that children will accept their parents' estate plan if the parents did it early in life, even if they would have changed it along the way, that they started that process early enough that they can show the pattern of thinking of how they wanted their assets to be transferred upon death. And as long as the parents did it and put that plan together, generally it's accepted by all the family members.
That makes
But
sense.
but again, that pattern in starting early is really important.
Mhm.
So some special situations that sometimes you have to address in trusts or estate plans is for minor children and grandchildren to make sure their inheritance is managed properly, but still provide distributions if they want to do things with the money that make sense. Also, sometimes people just aren't very good with money. So sometimes you have to address that in your estate plan by putting what they call total return trust to make sure that the assets are uh, managed properly for people who aren't necessarily that great with money. Also, planning for second marriages and unmarried couples provide its own unique sets of challenges to make sure because the presumptions that the law would apply to if it was a first marriage and children are all born in the marriage, those kind of get all thrown out the window if it's a second marriage or if you're unmarried couple. Also, planning with children or grandchildren or potential or heirs that have um, that are receiving disability, have on governmental aid, their inheritances often have to be put into special trusts to make sure that that doesn't create a disqualification from the various aid programs that they're on. So again, tying into the farm lifetime uh, transfer planning you're doing and the at death estate planning you're doing, make sure that your farm is organized in the best uh, business structure possible to make sure that your estate planning is easy. Also, the buy sell agreement you have in place for your business entity is important. Address it because it provides a baseline again what should be in the LLC or the trust as well. And estate planning is not necessarily just all about planning on what happens to your assets after you die. Estate planning is also talking about what your income needs are for why you're retired, and to how you're going to hold on, whether you're going to hold on to your wealth, or how much wealth you should hang on to while you're alive, and how much you should be giving away during your life. And that also ties into some, like, for example, life insurance planning. What are the needs are, very, very typical in a farm estate plan is that because the farm kids are getting a substantial amount of assets, i.e. the farm assets, that you have life insurance in place for the non-farm children to receive upon your death. Again, that all ties back to the estate planning um, uh, goals and objectives you're seeking to achieve. Also, you know, estate planning also ties back into long-term care planning. How much assets are you going to hang on to, until your old age? But what does that do for your qualification for um, medical assistance programs if you were to go to the nursing home? Should you be setting up uh, instead of revocable trusts, irrevocable trusts change trusts you can't change to divest yourself of assets in your old age. So quality and up-to-date estate plans for each owner are to make sure are essential to any farm transfer or succession plan. You want to make sure that when you're doing farm estate planning along with farm succession planning, a couple of these questions should always be answered to make sure that the succession plan and the estate plan are all coordinated together. So just to get on, I guess, on my soapbox for a moment, you hear a lot about, and you hear this, the cliche, fair is not equal, farm equity or sweat equity. Well, if it were all that simple, any farmer could go to ChatGPT or Claude and you could ask them to give your estate plan documents and provide them to you. The thing is, farm estate planning is more than that. It's delving into what you're seeking, your goals and objectives are, what your value system is like, what your special, unique situations are within your family, and molding those and putting those all together into creating something that's your plan. And with that, you can create, you can make the farm successful, and you can also have harmonious family relationships after you leave the earth, which I think which is everybody's goal. So, and in that, I guess my summary is, many people think estate planning and writing a will are the same, but one is really just part of the other. An estate plan is a broader plan of action that covers retirement, long-term care, tax planning, post-death administration, farm succession, management and co-ownership of inherited assets, protection of your heirs by their creditors and predators, and anything else that may be applicable to your situation. So that's what I have for today.
Wonderful. Well, we have had some questions come in, Troy, and I really just want to reiterate your point on the last slide about basically why you shouldn't use just anything that's artificial intelligence, because you guys provide a well-rounded, you're basically another advisor to the farm and making sure that the farm goals and the family's values are met within this transfer, especially when you're near the end of life. You've worked so hard for everything for your farm, and just to be able to know that you have the pieces in place to successfully transfer it to the next generation without having to worry about probate or tax implications, hopefully, or any of those other fun things. And really what you guys are just trying to be is you are an advisor to so many people. So just want to say thank you for always being a great resource, Troy.
You're welcome. Thank you.
Yeah, and so a few questions have come in. The first one is, so how much does an estate plan cost?
Again, it depends, but if you're looking at what I call the core documents, when I mean the core documents, it's the marital property agreement. I'm sorry, the health and financial power of attorney, marital property agreement, trust. Usually a range would be, and I know it's quite a range, but $1,500 to $4,000, somewhere in that range. So very rarely it doesn't, unless there's a lot of meetings and a lot of changes, it should not usually hit five figures. It would be strange that it would. So.
Perfect. And then another question came in. What happens if there isn't an estate plan and I die and have 3 children? I guess a situation analysis.
Okay. I guess it depends whether, I'm assuming 3 children, no surviving spouse or anything like that, I guess.
Correct. Yep. I would assume that.
Yeah. The presumption is it would go to all 3 children. However, because of it not going to a spouse, you can't use, well, you can, if your marital property agreement is drafted properly, you can allow for a non-probate transfer of assets, and not only to a spouse, but to children as well, too. But if without your marital property agreement in place, you would end up having to go through probate court to make asset transfers upon death.
I guess
Um,
how long, like for I obviously know nothing about probate. How long does probate typically take? And I guess what is the process of probate? Because obviously it's not great to have to go there. Um, yeah, I guess more information on probate.
so basically, probate, you have to file court papers to basically start a court action. And so you pay a filing fee to do that. Then you have to wait for the court to say that, and then you have to obtain permission from the potential heirs of the estate to appoint you as the personal representative or the executor. Um, and that takes some time. And then you also have to provide to the court a filed inventory of what the decedent owned at the time of their death. And then you pay a 0.2% fee based upon that inventory value. And then you have to provide to the court a final account of basically what happened to the assets while the estate was being administered and how those assets were distributed. And one huge negative about probate court, it's a court process. So anybody can go into the courthouse if you're nosy enough and find out what the person had when they died, because court records are public records. So again, it kind of not only is it does it become a lot more time consuming because of all these court processes you have to go to and wait for, but then it also makes your private affairs pretty public.
Does not sound like a fun system. So make sure to do estate planning.
Right. Yeah. Yep.
I guess with that, Troy, we're all out of questions. What are one or two key takeaways you want to really leave our listeners here with today?
I guess do your estate plan, start early, and change your estate plan along the way, and review it from time and make sure it is up to date to take account of the current situations that you're currently in.
All right. Well, thank you so much. Really appreciate the time today, Troy. Also want to say a huge thank you to you and the entire team at Men Law Firm. I know you guys are great partners with professional dairy producers and really just in our agriculture and dairy world as well. And we're grateful to have you as resources and friends here in our community. So thank you. I know you guys are a corporate partner of ours. So thank you to Men Law Firm, as well as all of our other corporate and national partners that make programs like the Dairy Signal possible. We look forward to seeing you hopefully here back again this coming Thursday for another episode of the Dairy Signal. But for now, signing off. Hope you have a wonderful rest of your day.